me some, Denmark v. State, 927 Southern 2nd, 1079, Florida DCA case from 2006. This was a case in which the defendant had raised insanity defense on a bat leo and resisting without violence charge. Two officers stopped him, asked for his name, gave a false name. When he went to trial, he indicated that he suffered from delusional paranoid schizophrenia. I'm sorry, the state experts concluded that he suffered from delusional paranoid schizophrenia, not insanity. Two other state experts opined that he was delusional or psychotic, but still could differentiate between right and wrong. Reports from the state experts referred to prior offenses, primarily juvenile offenses, committed by Mr. Denmark. They moved in limine to determine whether any testimony about the prior offenses would be allowed. The trial court deferred rulings as the trial progressed. Mr. Denmark again moved to exclude the testimony. Trial court ruled that specifics of the juvenile offenses should not be raised, quote, unless striking and important to the experts' opinions. Ignoring that admonition, the prosecutor asked one of the experts, and Mr. Denmark was thrown out of school at age 11 when he phoned in a bomb threat. Fair statement. The trial court denied the defense motion for mistrial. The prosecutor continued. Experts questioned experts about his conduct as a preteen. Mr. Denmark continued to object, renewed his motion for mistrial. The objections were sustained but denied the mistrial. Warned the prosecutor, I'm putting the brakes on, going back to the items that are so far removed in time and space. Then Mr. Denmark argues that the trial court, ultimately they said the court had erred in allowing the statements. The evidence of prior bad acts, Williams rule evidence, consists of prior conduct that may be admissible when relevant to prove a material fact and issue, including but not limited to proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. It is inadmissible when relevant solely to prove bad character or propensity. We haven't received any Williams rule notice. Indeed, the prosecutor never established a basis for using the prior offenses. The challenged evidence was factually, temporally unrelated to the January, to the date he was on trial for offenses. Accordingly, the relevancy rule of 9402 governs. Oh, I'm sorry. 927 Southern 2nd, 1079.
79, thank you.
Second.
79.
Relevant, so obviously the relevant evidence is admissible unless it's outweighed. When the unfair prejudice substantially outweighs the probative value, trial court should exclude the evidence. In that weighing process, the trial court may consider the need for the evidence, the tendency of the evidence to suggest to the jury an improper basis for resolving the matter, the chain of inference necessary to establish the material fact, and the effectiveness of a limiting instruction. Here, the trial court aptly concluded that the evidence had little, if any, probative value. The facts of his actual arrest, the facts underlying Mr. Denmark's January 2000 arrest, which is what he was on trial for, were not subject to much dispute. His sanity at the time of the offense was the key issue. For purposes of the probative value prong of 9403, the trial court acknowledged that Mr. Denmark's conduct from approximately 20 years earlier would not be addressed unless, quote, striking and important to the experts' opinions. The prosecutor repeatedly referred to Mr. Denmark's juvenile offenses without linking Mr. Denmark's January 2001 mental condition to the events that plagued him as a juvenile. The prosecutor established no probative value for the evidence. Under 403, the trial court should have weighed the absence. The weighing would have compelled the exclusion of the prior juvenile offenses. Instead, the prosecutor was able to elicit a testimony that could serve only to unduly prejudice, mislead, or distract the jury. And they applied harmless error test and said that they cannot, it was ultimately reversed and remanded. Then, so Judge, there's another case, but I haven't read it yet, just to let you know. Yeah. So as far as the, hold on, let me get this language down. On why it should come, if any relevancy would require that it be not necessary, but that court had, the trial court had said that it needs to be striking and important to the expert's opinions. The appellate court didn't say that, one, they hadn't established it was, they seemed to latch onto that yes, it needed to be striking and important, but unfortunately the prejudicial effect outweighed any probative value, which in this situation we have limited, if no probative value. It was offenses that are not related. I guess it's not relevant unless they're being introduced to dispute a material issue. And whether John was insane at the time he hurt Phoebe, it is not relevant whether John was violent with his mother in the past, completely unrelated to Phoebe, completely unrelated to mental illness, completely, there's no connection between the two for any relevancy. It is solely testimony of a prior bad act. Additionally, looking at Earhart, so I guess there's some issue on whether, when it is appropriate.
Where are you in Earhart?
Looking at, this is, oh yeah, that's right, 2018, 364.
Yeah. 364?
Yes, ma'am. It's 405.2. And another case that, that I was reviewing, a law review article actually that I didn't get that far into, but the issue I think that we're mixing is insanity and character are two different things. They're completely different. And so in this one, reading from Earhart, it says, evidence of specific actions may not be offered as the basis of an inference that because a person acted in that manner in the past, the person acted in that same manner on the occasion in question. Evidence of specific...
That's exactly what sanity is.
It is not, though.
They brought up a whole bunch of issues of how he acted in the past and what he said in the past, and that means he acted that way at the time. I don't... Talking out of both sides.
Okay, well this is...
Evidence of specific acts of an individual is excluded because it may be given too much weight by the jury, and because if it were admissible, a person would have to respond to charges of specific acts of misconduct that occurred throughout the witness's entire life. A trial would be sidetracked on minor issues involving the individual's past actions. A defendant may not prove his or her good character by proof of specific acts, nor may the prosecution prove the defendant's bad character.
He's meaning, well, this is sanity, though. We're not talking about character. And the bottom line is the PCLR, whatever it is, coming in through Dr. Burston, which I knew you objected to, in my mind, is basically kind of a character examination, really. I understand that it goes along with the diagnosis of borderline personality disorder, but all the traits in there certainly would reflect on one's character. That's coming in. I've already ruled that's coming in. Because I think the state's argument is, no, but even though he's mentally ill, that certain character traits he had led to the decision that it's not McNaught. And I think once you file that notice, you know, you're talking about a case where it was a juvenile history that happened 20 years before.
But it was an insanity case in which they were saying that it was his schizophrenia that caused him to act out, and the state was trying to say, no, it's just he wasn't insane at the time. He's just a bad person, and introducing
well, that's what Dr. Burston's going to say, I think.
Well, the second DCA said that's reversible error, so.
Well, if that's reversible error, then it is. If he gets convicted, it's gonna get kicked back. I understand that.
But I don't think we invite error, and if we're looking at a second DCA case that says this was reversible error and the state is presenting nothing that says it is not, I would ask that we err on the side of Mr. Jonchuk having a fair trial. I would ask if the court is still considering allowing her to answer this question, that the court reserve that and we can call her back after the expert testimony if the court feels it's appropriate. But I think at this point in time, it doesn't have any relevant value. It is highly, highly prejudicial.
I will agree with you on that. I mean, beating up your mother twice, that's bad.
All right, Judge,
I agree, but that doesn't mean, I understand, it doesn't mean it doesn't commit.
I got
Yeah.
lost in the woods though.
All right,
The question was, did it do violence in the past? The answer was yes. That was the answer by the witness. Stop. They brought up all that prior stuff. If they wanted to go into that, they brought it up. But the answer was yes. So the specific acts that they're complaining about, they now produce the specific acts that they're complaining about in the proffer. The answer was, the answer was yes by the witness, and nothing else until it was expanded upon. So
but that doesn't make anything to do with anything.
but the prior bad acts that they're complaining about that they don't want in evidence don't have to come in evidence. Is the answer to the question, did it get answers? Yes. If they want to clear that up, that's up to them. But the question, it seems to me, would be admissible based on what's come through this trial.
Your Honor, may I say one thing? If I have the juror question written down correctly, it was when wild statements, did I use the right word?
Yes, when wild statements were made in the past, did they ever lead to violence?
And when Ms. Manuel questioned Ms. Jonchuk about the specific act she was referring to, it was clear from her testimony that what precipitated those two acts of violence against her were just arguments. They were not wild statements. So I would suggest that when we carefully look at what the question is and what it was related to, which is the bizarre statement.
I got it, that's true. I mean, one of them was because she was mad, he was mad because he came over with Phoebe. The other one he's mad about some women out at a bar, and he breaks the television set, and he pushes her down the stairs. That's true.
It doesn't mean it didn't apply to other people. It wasn't violence against you, just that violence.
But when wild statements were made and what she described, I think she was ambiguous about whether there were wild statements. But what she described, she didn't say that she didn't know. She just repeated acts of violence. Two of them that would happened, and she explained what his motivation was as far as she knew. But it really wasn't, when the question was asked, she could not preface it with, yes, he was making wild statements, and then he did this. That's true. Okay, I'll reserve on it. I think it might be a big mistake. I'm not going to do it. I think it might be a big mistake. I'm not going to do it.
Okay.
I
So we're not calling
understand
her
what
back
they're
to the stand?
saying.
Are we calling her back to the stand to tell the jury we're not going to answer the question?
No, I'm just going to tell whoever wrote the question and I'm not going to answer it. Okay. Yes, and she's on standby, right?
Yes.
That was my
Yes.
understanding, standby,
So
right?
standby, make sure, Ms. Manuel,
Standby, right?
and make sure she understands. I think it's difficult for her to always understand. Okay.
Your Honor, may we go ahead? No? Never mind.
Okay, and keep in mind that I have to walk out at 11:45, and then I will be back at 1:15. question that was asked by a juror will not be answered. Please do not discuss the question with anyone. Thank you. You may call the next witness.
Defense calls Dr. Scott Mackless.
Sir, if you would stand right here for me. Please, look, raise your right hand, particular.
You do solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
And now, sir, if you would, step over here, have a seat, red chair, speak in a loud and clear voice for the court. Make sure you move up close to the mic.
Good morning, Dr. Mathis.
Good morning.
Could you tell the jury your name, please?
Dr. Scott Mackless.
And will you spell your last name, please?
Machlus.
One or two T's in Scott.
One T in Scott.
Doctor, what is your occupation?
I'm a licensed psychologist specializing in forensic and clinical psychology.
In order to pursue that occupation, did you have to meet special educational requirements?
Yes.
And what were they?
I have my bachelor's in psychology from the State University of New York at Binghamton. I attained that in 1982. I have my master's in clinical and school psychology, and I attained that at Hofstra University in 1983. I also have my PhD in clinical and school psychology, and I attained that as well at Hofstra University in 1986. From there, you do internships, you take licensing exams in order to become licensed and practice.
Are you licensed?
Yes.
In how many states?
I'm licensed in the state of Florida.
In addition to being licensed in the state of Florida, did you pursue any certifications?
I'm board certified in clinical psychology by the American Board of Professional Psychology.
What does it mean to be board certified?
It's a multi-step process. Individuals who are board certified, they review your educational requirements, they review your credentials, they review your experience, and then if you pass that stage, then you go to the next stage where you submit work product, you submit evaluations in which you've done, recordings of treatment that you have conducted, and they review that. And if you pass that stage, then you go to a full day of oral examination. It's a very complex, intensive process. To be board certified by the American Board of Professional Psychology is a distinction only about 5% of psychologists have in the United States.
Judge, may we approach?
I don't think we need to.
Doctor, what is the focus of your practice at this point?
It is in forensic psychology.
And what is forensic psychology versus clinical psychology?
Forensic psychology is where I do evaluations on matters of the law. I evaluate individuals in jails and in prisons, write reports that are used in court, and like today, testify in court. I've been doing this approximately 15 years. Prior to that, I've also did clinical psychology. Clinical psychology is where I did psychotherapy with individuals. I also did evaluations with individuals, but also did treatment at that time.
So in the course of your career, have you been asked to perform evaluations for the criminal courts?
Yes.
How many of those evaluations do you think you've done?
Approximately 820.
Now, doctor, in this, were you hired by my office?
Yes.
In addition to working for defense attorneys, do you also work for the court system?
Yes.
Can you tell me where it is that you, and tell me what is that process when you work for the court system?
Yes. I'm a court-appointed evaluator in the 5th Judicial Circuit of Florida. That's Hernando, Citrus, Marion, Sumter, and Lake counties, where I am ordered by the judge to conduct usually competency to proceed evaluations on behalf of the court.
How many times have you done competency evaluations?
Approximately 450 times.
In addition to your competency evaluations, have you worked with attorneys in the past in any other areas in the criminal system?
Yes.
What are the, tell me one of those or two of those.
I do mitigation evaluations where it's for purposes of downward departure, and that the court sometimes takes into consideration factors in regards to a defendant's life to determine sentencing. I've conducted death penalty mitigation evaluations where the issue of whether the individual will be getting the death penalty is being evaluated. I do risk for sexual recidivism evaluations, evaluations to determine or to give an opinion in regards to whether an individual is competent to waive their Miranda rights. And like in this case, I do evaluations looking at the mental state of the individual at the time or for insanity.
How many death penalty cases have you worked on?
Approximately 35, 40 cases.
Have you testified in criminal courts before?
Yes.
And in what areas have you testified?
In all the areas that I just spoke about.
Okay. How many times have you testified?
Approximately 95 times. I've testified in several judicial circuits in Florida as well as federal court.
How many insanity evaluations have you done?
Approximately 100.
Insanity evaluations can be asked for by the defense or by the prosecutor. How many, who do you work for more?
It's mostly for the defense.
And you mentioned 100 insanity evaluations. How many or what percentage of those did you find the defendant insane at the time of the offense?
Approximately 25% of the time.
We talked, you said that you were employed by my office. When were you first employed? When did we first hire you?
On this case, I was hired, it was either, it was in January of 2015.
Did you see Mr. JONCHUCK in January of 2015?
I saw him on January 30th, 2015.
Have any idea how many days that was after his arrest?
It was approximately 3 weeks.
When you went to see Mr. JONCHUCK, did he cooperate with you?
No.
Can you tell the jury, well, where did you go see him?
It was in the Pinellas County Jail. It was in the health unit.
When you said that Mr. JONCHUCK would not cooperate with you, can you elaborate?
Yes. When I saw him, he was naked in the middle of his cell. I tried to engage him to get information from him to be able to conduct an evaluation with him. He did not respond to my questions. He either mumbled, he either did not respond at all, or he mumbled to himself, but I could not make out. It was incoherent, the things in which he was saying. So I tried for some time to get him to respond back to my questions, but he never did.
At that time, did you tell him that you were hired by his defense attorneys?
Yes.
Did you tell him that before he was uncooperative?
Yes.
I want to clear up one thing I asked you. You mentioned you've done about 100 insanity evaluations. Are those all in homicide cases?
No.
So then the 25% of the time that you have found someone to be insane, those are also not all in homicide cases?
The insanity cases are not all homicide cases.
After you saw Mr. JONCHUCK in January of 2015, did you go back the next day or a week later?
No.
When was the next time that you saw Mr. JONCHUCK?
It was in February of 2017, approximately 2 years later.
What was the purpose of your going to see him on that day?
I saw him at the state hospital and I did an evaluation of his competency to proceed.
Did you? Was he cooperative?
Yes.
Was he clothed?
He was clothed.
And did you find him incompetent?
Yes.
Quick question, Your Honor.
Doctor, moving on from that evaluation, did you see Mr. JONCHUCK again after that?
Yes.
And when was the next time that you saw him?
If I can refer to my report.
Yes, please.
I saw him on July 14th, 2017, and July 24th, 2017.
And was there a specific purpose to those evaluations?
That was to pursue my evaluation on his mental state at the time of the offense, or whether he was insane at the time.
All right. So when you conduct that type of evaluation, so now we're talking about the evaluation that occurred in July of 2017 and continued on. What do you do? What do you need?
Well, what I need for when I do conduct a forensic evaluation is I look at police records, I look at mental health records, medical records, I interview the defendant, I gather information from collaterals, which are family members, people who know them, and when I feel that it is important to conduct psychological testing as well.
Okay. Now, you said that you gather information from collaterals. What's that mean?
Collaterals are interviews with family members, with friends, with people who knew him at, depending upon the type of evaluation, but certainly in an insanity evaluation, around the time of the offense, and could speak about his mental functioning at the time.
So it's to gather information that those people would provide?
Yes.
Does it have to be in person?
No.
What are some other ways that you can gather that information?
That information can be obtained through police reports. It can be obtained through depositions.
And in this case, did you obtain information from the collateral sources from the police reports?
Yes.
Did you obtain information from the collateral sources from depositions?
Yes.
All right, that is the general process that you employ in conducting your evaluation. Is that right?
Yes.
All right. Specifically in this case, did you review documents and materials that we discussed?
Yes.
What documents and materials did you review?
I reviewed numerous records and documentation. I reviewed the St. Petersburg Police Department Incident Investigation Report, the St. Police Department Supplemental Reports, the St. Petersburg Police Department Arrest Report, the Rights Advisement Form, the Manatee County Sheriff's Office Case Summary Report, the Hillsborough County Sheriff's Office General Occurrence Hard Copy, the Hillsborough County Sheriff's Office CAD Call Hard Copy, the video of the interview of John JONCHUCK at the Manatee Police Department, the report of the autopsy of Phoebe JONCHUCK, text messages between John JONCHUCK and Michelle Kerr, Department of Children and Families reports, case summary, case number 14DR019102, an order denying petition for injunction for protection against domestic violence, a petition for adjudication of dependency, an email from John JONCHUCK to Tasha Clare, an affidavit for search warrant, criminal history of John JONCHUCK, deposition of Julie Bryan.
Let me stop you for a minute, because you reviewed a lot of depositions, correct?
Yes.
And these depositions are of witnesses in the case?
I don't know.
But, okay. A deposition is a statement that a witness makes?
Yes.
Okay. I don't want you to read through all those. And then, how about any records from you mentioned that you went and saw him in a hospital. Did you review those hospital records?
Yes.
And also, did you review any records from any prior treating physicians of Mr. JONCHUCK?
Yes.
That covers the records. You also interviewed Mr. JONCHUCK.
Yes.
And how long were each of those interviews?
Well, my interview in February of 2017 was an hour and a half. My interview on July 14th, 2017 was 3 hours. And my interview on July 24th, 2017 was 2 hours and 15 minutes.
As part of your evaluation, do you collect any other, for instance, identifying information regarding Mr. JONCHUCK? Any way that you can tell us, for instance, who he is? Do you look at things
Mr.
like...
Williams, would this be a good time to break?
Yes, it would.
Okay. Dr. Mathis, we're going to be in recess for lunch until 1:15, okay?
Okay,
Thank you
thank
very
you.
much. Ladies and gentlemen, 1:15, come back. Dr. Mathis will continue with our lunch break. Please leave the pads on the chairs. Thank you. Okay, hold on. We got something you might need to know about. The payment will be open on the second floor until 1 for jurors to stop by and collect what is due for you this week. Unfortunately, due to a computer error earlier in the week, 2 jurors, Mr. Miranda and Mr. Vroom, have been overpaid by $30. Hold on. If possible, we need them to stop by the second floor to return those monies. Hold on, I will gladly make myself available if any jurors have questions, and the gentleman's name is Justin Gross. These are my marching orders. Thank you. Oh, yes.
Jurors out of the hearing in the court, Your Honor.
Thank you. Well, we can be at work.
All rise. Being recessed till 1:15 according to the courtroom clock.